Good afternoon, everyone. My name is Laura Bacchus, and I'm the director of Dykema's Automotive Mobility and Transportation Group. Thanks for joining us today for our next installment of our Dykema Drives webinar series. Today, we've got a great program for you, which I like to call the Clay and Jay Show. You will see their bios a bit later in the program or in the PowerPoint. I'd like to introduce you to Jay Logel. Jay's resident in our Bloomfield Hills, Michigan office. Jay is the leader of our automotive regulatory group. And one great thing about Jay is that NHTSA will answer his calls. He's on their direct dial list. So welcome, Jay.
Thank you, Laura.
Next up, we have Clay Kosei. Clay's resident in our Dallas, Texas office. Clay is one of the leaders of our EV AV group. And Clay is a product liability trial attorney. Welcome, Clay.
Thanks, Laura. Great French pronunciation on my name. Appreciate it.
Appreciate it. Get it right after 32 times. Today is a CLE eligible program, so you will get the information when the PowerPoint is sent to you afterwards. But you can always reach out to me, Clay, or Jay with other questions. With regard to questions mid-program, there's a chat box. Jay and Clay will try to watch that. If not, if you leave contact information, they'll get back with you, or you can always reach any of us later. Like I said, I'm the director of our automotive group. We have 13 offices nationwide, most importantly throughout Michigan, in the Midwest, in California, and throughout Texas to help you with your mobility needs. And we are a full-service automotive and mobility focused firm, everything from antitrust to supply chain and everything in between. Dykema does do this webinar series about 5-6 times a year. If you have any ideas or suggestions, we'd love to hear from you and what you're interested in. We also do, as one of our main series events, is an in-person conference in the summer at the M1 Concourse in Pontiac, Michigan. So this year it's on August 20th. We'd love for you to join us. We talk about hot topics impacting the legal industry, as well as some fun events on the racetrack. So once you get the PowerPoint, feel free to click and learn more about the in-conference event. And you also can register right from our website. With that, today we're talking about AV, regulatory issues, as well as product liability and trial. And with that, I will leave it to Jay.
Great. Hey, thanks, Laura, and welcome everybody. Please send us questions either during the presentation or afterwards. We'll be happy to answer them. We're going to start off with a little discussion about sort of what's going on in the motor vehicle safety world, what's in the news. One of the big things going on right now is the Department of Transportation with NHTSA has started this national AV framework. They're working on several aspects all at the same time. It's a huge push for Secretary Duffy. It's one of his top 6 objectives, and so it's getting a lot of attention and a lot of activities going on. We'll fill you in on that. One of the things I like to do when I talk about AVs and ADAS is put it in the context of what's going on in terms of motor vehicle safety. Motor vehicle safety is a leading cause of death in the U.S., and about 40,000 people a year pass on our roads, and well over 2 million people are injured. So this is it's just a major safety issue, and most of the causes of accidents in the United States, well over 90% of them are caused by driver error. And so when I think about AVs and ADAS technology, I think about what we're doing in the next frontier of improving automotive safety. And I know there's a lot of fear around some of these technologies, and Clay will touch on that. But I don't think we're in a space where we can do nothing, given the numbers that are here. One of the things that's interesting, and it sort of reinforces the behavior issue, is during COVID, we had a terrible spike in the number of fatalities on the roadways. Even though miles driven went down, the number of fatalities went drastically up, as a huge jump compared to a long-term downward path over 20 years of improvement. And I think this just goes to show, excuse me, that driver behavior is the leading cause of it. The vehicles didn't change, the environment didn't change. The only thing that changed is who was driving. And apparently, all of us that were home protecting ourselves from COVID were on the roads, and only Clay and his group were out driving around wildly. Now, it's clear that behaviors changed even during that period. Interestingly, we've gotten back down. We see this steady decrease in fatalities per vehicle miles traveled, and that's great news. We're getting back to a good, safe level. Hopefully, that will continue. But I think, and for that to really make a monumental change, this technology is going to need to help. And Clay, can you talk about sort of attitudes people have?
Sure. Yeah. I think it's so interesting that per capita, that last slide, that you showed us, per capita or per mile driven, people, it's as safe as it's been on the road since 2014. And just as kind of chaotic as modern life is, I wonder if that message is making its way to people. But I do know that at least as of AAA's 2025 survey, driver attitudes towards self-driving vehicles were pretty lukewarm. If you look at these numbers, and they're more or less flat over time. Haven't seen the 2026 survey from AAA. I would be interested to see it. I would bet it would be an incremental change, if anything. But yeah, more people by far, almost 90% of people are afraid or unsure about about self-driving vehicles. That's really enlightening, and the attitudes generally are, I remember from that survey, are about the same as to self-driving vehicles as to ADAS features. People are just generally hesitant about the technology. So, just dovetailing with consumer attitudes, you may have seen, just to talk about juror attitudes a bit, but y'all may have seen this Wall Street Journal article recently that just talked about the divide in the jury room, and it was really interesting. A lot of it was, what we would consider to be fairly obvious, being in the industry, but they did a case study on a Florida jury in an opioid civil trial. And it was a lawsuit that alleged that three big pharmacy chains had flooded the state with prescription opioids. And it was an entertaining article. There was an agreement among the jurors to wear thing one and thing two, thing all the way up through thing nine costumes, and one guy didn't wear his, and everybody got aggravated, and he put the thing one sign on for the picture, and then got aggravated and took it off. And but beyond that, one juror made an AI PowerPoint presentation at home, and showed it to the other jurors, and then the same juror had AI write a note to the judge about another juror's improper conduct, and she accused him of meeting with defense lawyers in the bathroom. So it's an interesting read, and seems to be kind of a wild jury deliberation, to say the least. But there's some interesting stats that they discussed in the article. And if you see here, so they looked, they cited studies of prospective jurors from 2018 through 2025, and the one at the bottom is very interesting. Negative opinions of corporations went from 24% to almost double that, to 47% in 2025. How many people, this one's so interesting. How many people would follow the conscience or their conscience or personal beliefs over the law? That one's at 65%. More and more I say, like, just give us jurors who we can trust to follow the law. And that's really, I think, a special sauce in voir dire and finding who your jurors are. Will they follow the instructions of the court? Will they follow the evidence? Because the evidence is usually on our side. So very interesting there. Elsewhere, in vehicle safety news, NHTSA released a press release on the Tesla Model Y being the first vehicle to pass its ADAS system test, which is basically NHTSA's rolling out an NCAP system for an NCAP kind of rating system for ADAS systems. And I think we may all have noticed that rulemakings have been pretty slow in pace over the past 5, 10 years. They're just have NHTSA's not doing a lot of rulemaking, seems to be really bogged down. But this really seems to be a way that they see as something that they can be really active in over the next 5, 10 years. Can you tell us about the nuts and bolts of this, Jay?
Sure, Clay. There's NHTSA's published a 10-year plan, and we could go into great detail about all that, but we don't have time for that right now. But currently, they have an ADAS performance requirements for forward collision warning, lane departure warning, crash imminent braking, and dynamic brake support. And then in 27, they're moving towards additional tests. Well, this is an example of if you go to the NHTSA website, you can walk through each of these. It'll walk you through what the test is, what the technology does, and it's really their website's actually pretty informative. Um, what's interesting is the technology is changing so quickly that we've got these recommendations for this NCAP through 18 through 26 model year, but now in 27 model year, they're adding all these other test modes. And the test modes basically add higher speeds. They add more circumstances, for example, pedestrian, both day and night detection of braking, not only blind spot warning, but blind spot intervention. The lane keeping assist is a more sophisticated test, and they test over a range of speeds to see when each system starts to fail. And if you get so many failures, that's sort of where you end up. And rather than a 1 through 5 star that you're familiar with for crash testing, this is really an up or down mode. You either pass or don't. And Tesla has not only passed the 26 model year test protocol, but has also passed this early adopter 27 model year test protocol. So it's really a great accomplishment, and it shows you what this technology can do. I think it's pretty exciting time with the technology moving that all of you are dealing with if you're working at any OEM or any supplier.
And for litigation, I mean, we're good. This is something we're obviously going to deal with. It's going to be the first thing we see. We'll see it, put in petitions. Yeah, I mean, we may see it put in if it's all checks. I doubt we will. But if there's a bunch of X's, it's going to be binary, a check or an X, right? And
Yeah.
if there's an X relevant to the the ADAS system that might have been relevant to your crash, then obviously we're going to see that. So this is interesting. In the bipartisan infrastructure law, there's a mandate for kill switches for intoxicated driving. I've written about this in the past. This is just something in the news with all the angst about AI. There's a lot of concern about vehicles being disabled. What do they tell the operator why it's disabled? When does it turn back on? And then can AI be used to hack your vehicle and shut it down? This is all very much in the news. Excuse me. Back on the NHTSA front, I had a case that kind of peripherally involved hot car deaths and what technology can be used, to mitigate these horrible injuries to children. And this is, as you'll see, this is one of the most visible, I think, is one of the most visible things that any of us see from NHTSA, and probably that any of us see related to vehicle safety, is the hot car deaths campaign. And just kind of, I think, goes along with NHTSA focusing more on, on their persuasive authority, on marketing, education, NCAP versus formal rulemaking.
And Clay, the driver monitoring and the detection of occupants is part of the 10-year NCAP plan. So these things will be tested in the future. At least that's where they're headed.
Right.
So at this point, I'm going to talk about what NHTSA is doing with this AV framework. They've had a lot of publicity around it. There's been a lot of press conferences. Like I said, it's a top priority for the Department of Transportation. And when it was announced, there were two big elements, I think, driving it. One was China and the developments in the Chinese auto market and all the technology innovations there. They want to make sure the U.S. is competitive with the Chinese technology development. Um, they also want to work on getting rid of red tape or any regulatory uh, inhibitors, and that's really what they're focused on. And there's been a lot of activity in this space over the last couple months. I mean, this is really focused on this. What's the AV framework? Essentially, it's announced a couple elements. One, it's going to prioritize safety, unleash innovation, to compete with other markets, and enable commercial deployment of AVs. They really see the Waymos and Teslas of the world who are going out providing rides to people. They say, "Oh, we need to get more of that because we need to get more of that experience to understand how these products are going to work and develop the technology." Now, the policies that they're pursuing to achieve these goals are they're revising the exemptions for AVs. They're expanding them. They're applying them to U.S. manufacturers. And the exemptions are about vehicles that don't have human driver controls. And I'll touch on why that's so important. Second policy announcement was they revised the standing general order reporting related to AVs and ADAS. And those of you who are responsible for SGO reporting, hopefully you're breathing a bit of a sigh of relief. And they are updating FMVSS to accommodate vehicle designs without driver controls. And they've launched some of that already. So what's the problem that this framework's trying to solve? The problem is NHTSA has interpreted its regulations related to human driver controls as being applicable to vehicles that don't have human drivers. In 2016, the Chief Counsel's Office issued this, what's called the Google One interpretation, saying there's no regulations prohibiting autonomous driving systems, but they all have to be equipped with the human driver controls. And those are things like mirrors, foot controls for brakes, hand controls, transmission selectors, and then the various warnings. And that just inhibits broad-based development of these vehicles because that's a lot of extra cost. It adds a lot of safety problems if you have a system that's designed to be operated without human intervention and all of a sudden someone pushes on the foot brake. That's an input that's going to be very dangerous, and companies just aren't willing to go down that path. NHTSA did revise in 2022 all the occupant protection FMVSS, and it was a lot of wording about what's the driver position and things like that. So I think that was fairly low-hanging fruit. The other thing NHTSA did that reflects the problem is NHTSA challenged Zoox, who certified their vehicles that didn't have driver controls as conforming to FMVSS. And NHTSA challenged them to say, how can that be if we have FMVSS that require driver's controls? And as part of this framework, they resolved the Zoox question. So one of the things I'm accused of being is a sort of a geek or a nerd about administrative law. And there's been a sea change from the Supreme Court in the last 5 years of opinions interpreting different aspects of administrative law. And I think when you look at what's going on with NHTSA and the Google interpretation, I think there's a lot of opportunities to revisit that under this new Supreme Court direction on what administrative law means. And I think all of you should be aware of that. It's something I could go on and talk about forever, but I'll try not to. Clay's asked me to try to control myself regarding talking about administrative law.
Yeah, I just have to disagree with you on one thing. I don't think you're a geek of administrative law. I think you're the Miles Davis of administrative law.
I love you, man. I love that you said that. That's so good. That's why Clay and I do this together, and that's why he gets first billing because he says nice things like that to me.
We just
Um,
need a laugh track for this.
you do. That's the problem. I know that people are rolling, laughing, and that we just can't hear it.
Yeah.
Um, Now, what has NHTSA done in terms of pursuing the policies? Like I said, they recognize receipt of Zook's exemption petition. They've sort of already said they've granted it, but now they've received it and they're going to go through that process. So they're making peace with Zook's. Zook's is seeking the exemption process that NHTSA laid out. And again, that's sort of we have exemptions for a certain population of vehicles for a certain time period. It's not 100,000 or a million vehicles on the roads at one time. They did amend the SGO, as I described, and made the reporting, I think, more reasonable. Um, they also have started a bunch of rulemaking this year, uh, all focused on changing these rules so they can accommodate vehicles without driver controls. Uh, there's the ones that they've started. They have not addressed the toughest ones, which are brake controls and the mirrors at this point, but they are taking a lot of action in this space. I think one of the things when you look at the framework and you look at what else is going on in the world, the framework really keeps the U.S. industry uh, in an exemption process, in a test mode for the time being, because the rulemaking activities, they're working hard, they're going to go fast, but that takes time. And during that time frame, uh, China is acting much more quickly. There's also been some legislative activity. I don't know if the Self-Drive Act, many of you are probably aware of it, but it's actively being pursued. But I don't know if it's actually going to see the light of day in this Congress. We just don't know. But China, on the other hand, had a big accident on a Xiaomi vehicle, the SUV in China, where I think 3 people perished in a vehicle fire. A very sad event. And within months, China issued a whole series of new regulations to try to get a handle on regulating AVs. And when I look at this, I see this as sort of a potential roadmap, and I'll ask Clay about this. I'm worried that this is a sort of potential roadmap that a plaintiff's attorney might use in the future to say, "Oh, your vehicle's defective because you have a yoke steering wheel or whatever." This just gives it to me a list of defect theories that they might attack. But I don't know, Clay. You're the expert in product litigation.
Yeah, it's interesting. We frequently hear in products liability litigation about European standards. We hear about vehicle technologies used in other parts of the world. We haven't yet dealt much with Chinese regulations, being a leader or driver, or the allegations that we see. And these are that you list are interesting. The door handles, physical controls, prohibition on yoke steering wheels. My initial reaction was these seem to be not commonly used technologies in the US. And are they directed at one manufacturer or another? And I think you said, and did you say these are all very common in China?
Yeah, in the Chinese EV market where they've got a lot of these, they're level two uh, technologies, but they have a lot of ADAS technologies that's exploded, and these are very common design features. And the
Also,
Xiaomi company that had that accident, these are all related to things that were in that vehicle design in particular.
I also like your AI generated image. It's a very, very creative image, but the AI still can't spell regulators.
That's the great part. And the 2 drivers only have 3 hands. I love ChatGPT for drawing images, and that might be an example of why you can't trust AI yet for your legal briefs. There might be a few mistakes. So the other way NHTSA regulates, besides regulating through FMVSS, is they investigate and they have safety defects and they have recalls, and that causes the industry, as we all know, to adopt around some of these recall practices. And they've been very active in this space. Interesting, this last 4 years sort of tells us where safety recalls have occurred. And when you look at it, you think, and there's some limits in what I can search on the NHTSA website, so I've had to categorize things the way NHTSA has them categorized a bit. But you look at forward collision avoidance technologies like forward collision warning, um, crash imminent braking, AEB, things like that, which are fairly widespread in the industry, right? Lots of vehicles, millions of vehicles have the technology. The number of recalls is fairly low, given the number of vehicles that are out there. But what's interesting to me is ADAS. These are vehicles that these are automated driving systems, right? These are vehicles where the vehicles are driving. These are level 3, 4, or 5 vehicles. There have been, given the small number of vehicles that are out there, this has been an active area for recalls. Now, on the investigation front, you see this is over the last, like I said, 4 years up to today. You see again that level 3 plus vehicles are under really tight scrutiny. And I think these numbers are fairly high in general, I think, for the technologies that are out there. But I think this is an indication of how the SGO is driving NHTSA to open investigations, because every crash in one of these vehicles that's reported to a manufacturer is reported to the SGO. So some of these investigations are driven by one event. And it's if you're working in this space, you can expect that you're going to be under a NHTSA investigation.
Seems like the regulators have the time and they have all this information, and it's like, man, we got to do something with it, right?
Right. I mean, the TREAD Act from many moons ago gave them a lot of information and not much in terms of recalls was really driven out of the TREAD Act reporting, though it's a huge burden. The SGO, on the other hand, has really, I think, driven a real sea change, a big difference. That's right, Clay. And when I work on these investigations for companies and I review what they're doing and what NHTSA is doing, there are a few issues that are coming up in this space. And as a reminder, you have to do a recall in this under 3018 of the Safety Act when you have a defect that's related to motor vehicle safety. And the two most prominent cases deciding what a defect means, wheels and X cars, says a defect is a significant number of failures compared to the general population. But in this context, with this technology, what's a failure? Is it a failure about the capability of the software or the sensors? One of the things that NHTSA seems to be very focused on is violating a traffic control or a lane marking or something like that. We get a lot of questions, a lot of discussions around that. Is that a defect? I'm not sure that constitutes a defect, that is something they're looking at. And then they're also asking questions around your ISO 26262 safety goals, your safety case. And again, these aren't related to failures. These are just how you're designing your vehicle. So it's a very different focus. And the agency is trying to understand what to do in this space as well. It's not like they've been given a roadmap that perfectly outlines this. And then on the question of significant number of failures, one of the things that I've explored with the agency is to whom are we comparing this performance? If it's in the general population and you're asking about traffic controls, for example, there's a lot of data that says a stop sign is blown every 20 minutes in this country. So that's a lot of stop signs every day, every month, every year. Are these ADAS technologies and are they being held to a standard to be better than human drivers, right? Are we comparing it apples to apples between different technologies? Is that really the right comparison? Should we be looking at the ASIL ratings under ISO 26262 to say, oh, your ASIL rating wasn't low enough, so that's the definition of a defect. And the information requests are really getting broad. Again, as the agency trying to figure out how to define a significant number of failures posing a safety risk, and they're looking for different paths to go down. one of the things I find interesting is they're relying a lot on events reported in social media. And I would ask if they're going to claim that you should be aware of this and this should be noticed that you have a safety defect, it seems like we all need to be watching our social media or just social media in general. And I wonder how many companies are doing that for these sort of events. Um, another thing I talk about is the safety case. I'm very focused on that. And I would ask if a particular design violates some aspect of the safety case, would you declare that a defect absent any field events and just recall it? It seems like that's the direction they're trying to go. They also ask for a lot of video information. It's out there, it's interesting to them, and they're asking for large amounts of video information in ways that companies aren't holding the data. So there's always a discussion, well, I'd like this amount of data in this format, and the companies either have to spend a lot of time recutting the data, or they just hand over the video that they have. It's an interesting time, and these are just topics you didn't have before. I'll give you a couple examples. Here's a investigation as prompted by SGO again. It's about collisions in reduced roadway visibility conditions, and here's the population of vehicles. So it seems it's an understandable scope. But then in the next IR for this investigation, they switched it and they said, well, the investigation was about collisions in reduced roadway visibility. And now they've said to Tesla, we've heard about your robotaxi plan, so we're just going to use this investigation to investigate robotaxi in general. So it's a real departure from the subject matter of the investigation. And I think this is something you should be aware of. Just to give you an example of asking about compliance to industry design standards, not even industry standards, just broad-based standards. Again, this doesn't relate to failures. It just says, what are your design standards? And that's just an interesting process. I worked on a lot of investigations over my time, and very seldom did NHTSA go down this path on a brake or steering investigation. Again, they ask about, this is, it's about allegedly collisions in low visibility, but then they ask about your interactions with first responders. They ask again about your compliance with traffic laws. So again, the investigations are just getting very broad. Here's another example where the subject system is the entire suite of software, hardware, data, any related aspect of the vehicle, on or off the vehicle. So they're also looking at your back end efforts and what you're doing there that have anything to do with automated driving. And something I've seen in some of the automated driving investigations, they stop talking about subject defect. They just talk about subject behaviors. Again, I don't know how that's going to translate into a defect analysis, but I just show these examples of how the investigative process has really started to expand in this space, and NHTSA is trying to understand their role. And I think you need to be prepared for these sort of questions and think about what lines you're going to draw in terms of what you're going to provide. And that's sort of the NHTSA world. And now I'm going to shift to Clay's world of litigation activity. Take it away, Clay.
Thanks, Jay. Very interesting indeed. And I think that's part of the problem, is that it's so interesting how much information is coming to these regulators. It's just so fascinating, and they have video of all this stuff. So it's like, yeah, let's dive right in. But yeah, so, litigation climate, there's so many things we could talk about. We all know that, jury verdicts, the numbers are huge in some cases, but there are also lots of defense verdicts and dispositive motion wins. And I want to talk about some of those here today. As we discussed earlier, trust of the judicial system is extremely low. It's gone way down in the past 7 years. Trust of corporations, same thing. And people are generally, you saw the number, 65% of people would put their personal judgment above the law. and they don't really want to listen to the law or the judge or even the evidence sometimes. So there's a lot of things we could talk about here, but one thing I want to talk about is kind of a lesson learned in a recent win, and that is just causation and diving into the expert discovery, the expert opinions in dispositive motion practice. It's often assumed by the other side that if there is what I'll call a pertinent ADAS, if there's an ADAS system that's relevant to your type of incident mode, that it would have, especially if it's a warning, it's kind of just assumed or glossed over that it would have prevented the incident, or that the vehicle should have had it. But historically, warnings in particular are not typically completely effective. It has to be proven that they're effective. What empirical research, what naturalistic studies, what surveys does the plaintiff have to prove their case? Are people even using the technologies, or are they turning them off? Like this graphic shows that, it can be at or below 50% that people even have the technologies turned off. So is it a technology that can be disabled and turned off? But generally, what we've learned from working with the experts especially on warning type ADAS systems, is that drivers, they quickly learn the alert timing, they learn the escalation logic, and they begin and pretty quickly to anticipate responses and avoid severe warnings. Their response efficiency improves over time. Drivers also begin to adopt just-in-time engagement strategies, and they kind of cycle between disengagement and brief re-engagement, and that's something that we see. So these, a lot of warning-specific ADAS systems, drivers will learn to do kind of just enough to keep the system from aggravating them, and then they kind of quickly return to disengaged states. So even if there's evidence that a warning would have potentially would have created some type of response that might have prevented your incident, what are the other effects, right? Is it causing more disengagement over time? So again, I'll just start with, to kind of dive into the case studies here. Frankowiak versus Kia. This is a case handled by, excuse me, yours truly, and some other of my awesome colleagues, Mike Carey and Tara Kern at Dykema. This is a automatic shutoff allegation, was the defect allegation. The plaintiff, so the plaintiff and the decedent were an elderly couple. They returned to their home after an unrelated hospital trip. They left the vehicle running in an attached garage. One of them died and one of them sustained CO exposure injuries. So the allegations in that case were that the subject, 27 Kia Sorento, should have had automatic shutoff for situations where it's left running, and that it should have had louder, more conspicuous warnings and alerts. So it's true that the vehicle wasn't equipped with automatic shutoff. It's a complex problem, but fully 90% of vehicles were not equipped with automatic shutoff as standard equipment in 2017, the year that vehicle was sold. And as far as warnings and alerts, this vehicle had best-in-class cues, warnings, and alerts. So we filed a motion for summary judgment. It's very fact intensive, and that's one thing to look at and be aware of today, is that a lot of these ADAS cases, we need to be very proactive about diving into seemingly fact intensive issues in dispositive motion practice, because a lot of times there really just isn't any there. One of the issues that the court in our case, I think, found so convincing was that there were there's no empirical testing, naturalistic studies, surveys. There really wasn't any scientific evidence that the warnings that were proposed by the plaintiff would have prevented this incident. Another aspect, or actually, to just dive into the evidence a little bit. So, our experts, like I said, did some market research and found that this technology just was not in very many vehicles at all the year this vehicle was sold. 91% didn't have it standard. 84% didn't have it at all. So that was extremely convincing to the court in and please try to hold back your howls and screeches about this phrase, but the consumer expectations test. So the court actually examined the auto shutoff claim in the context of consumer expectations and said there's no way that this claim could pass muster under a consumer expectations test with this kind of just very nascent implementation in 2017. On the on the warnings, we showed the court that our vehicle had best in class warnings for when the vehicle's left running. It was, I think, it was the loudest. No, this is duration, right? So it was the longest in class warning, and it was the second loudest. So again, the court found that this is not an issue that was beyond the expert, beyond the abilities of normal consumers to understand, and found the expert evidence convincing, and the plaintiffs' experts were daubered, and the court granted summary judgment. Another case that's very interesting is Shelton versus Hyundai. This one's from May of 2025. And this is an interesting case. It was actually the vehicle was being operated by Coleman Shelton, who's an offensive lineman for the Los Angeles Rams. The plaintiff, his father, put his hand under the top of the window frame, and his son closed the window, trapped the plaintiff's hand. He injured his hand. So this case was filed in Los Angeles. And so the defect allegation was that the vehicle's auto reverse feature should have detected fingers in the door. So so that case was tried, defense verdict on May 12th, 2025. So it's not just dispositive motion practice, but despite the difficult attitudes and the difficult climate, defense verdicts are, when we have the time to educate the jurors, defense verdicts are still, not uncommon, especially when the defects are totally specious like this. Ayers versus Ford. This case was tried in November of 2025 in federal court in Georgia. Federal court, I guess even in Georgia, continues to be our friend. And the allegation in this case was that the vehicle should have been equipped with an automatic emergency brake. The vehicle rolled down a steep hill and struck a tree, injuring two passengers, and that was after the driver exited with the transmission in reverse. So our friend Ryan Clark of Lewis Thomason tried that case and got a defense verdict November 19th, 2025. So yeah, very interesting. We're not just seeing ADAS cases in the what I'll call the collision space. It's also, although this was obviously a collision, but it's also vehicle ingress and egress, as we saw in Francowiak, and again, we're seeing ADAS allegations just as to anything you could possibly imagine. And this actually filters over into not just automotive, but we represent heavy equipment manufacturer clients, truck clients. We'll see a trucking verdict here soon, but the ADAS claims are proliferating, and it's just really just about anything you can think of. Hunter versus Daimler Trucks was an interesting case. That one was tried in December 2025 in Connecticut. It involved a 2016 Freightliner Cascadia heavy truck, tried by our good friend Larry Coben, who we all love so much. If you're listening, Larry, I don't think you are, but we love you. So this is a case involving a box truck rollover. The Freightliner collided with a rolled over truck, and the plaintiff was injured and just was sustained quadriplegia. So the allegation was failure to equip the truck with ADAS, specifically forward collision warning and automatic emergency braking. So the defense was, that obviously these vehicles are safe without ADAS, and in that the collision mode at issue was beyond the technical capabilities of ADAS in any event. So that one, again, defense verdict in December of 2025. So don't be discouraged about the litigation climate. If the allegations are specious, as we're seeing in so many of these cases, jurors will listen. Sometimes the mocks are scary, and we hear some real wing nuts, and the Wall Street Journal case that I talked about earlier obviously shows some of the more insane behavior. But with enough time, we can educate the jurors, and they will, they can be brought to see the truth. uh, Lastly, this one's interesting. It's not an ADAS case, but my colleagues Mike Cooney at Dykema and Daniela Gonzalez Aldape, they tried a case in Las Vegas for General Motors. The allegation was lack of a rear center seat belt, and this one's notable again not because this was a defense verdict, but it's notable not because it's an ADAS case, but this was submitted under consumer expectations, and I will tell you that in this case the my colleagues' cross-examinations of witnesses, of experts on the other side, their openings, their closings, their presentation of the case as a whole was extremely curtailed by the judge. They barely got to put on a case. They didn't introduce a single exhibit. Well, I say they barely got to put on a. They really put on very little evidence, maybe one witness in their case, and again, like I said, some of the most basic questions were curtailed by the court. But this is another one that was submitted under consumer expectations test, and in which we're hearing more and more. It's in some cases, in the right cases, it's not the thing to fear that it once and has been thought to be. So finally, this is just product liability filings by manufacturer. This was done earlier this year. There's 4,600 filings nationally. So things are not slowing down in the space, if I can use the automotive metaphor. The litigation is booming, and the ADAS claims are really proliferating and taking over. Get a good lawyer if you and Dykema has plenty of them. If you have a gnarly ADAS case to attack. And with that, I believe that concludes our formal presentation. Jay, do you have any thoughts on the litigation stuff? Any questions that you want to be an interlocutor for while we wait for questions from the audience?
Sure. One of the questions is sort of specious, and that is, are you suggesting that you can win cases without witnesses, without exhibits, and essentially without any opportunity to present much of a defense? Is that what I heard?
Mike Cooney and Daniela Gonzalez Aldape,
They do that.
They can, and they did. I don't know if I can, but yeah, it certainly can be done.
That was incredible, right?
Yeah,
I mean,
it's
what
amazing.
little they had to go on was just
Yeah.
incredible.
Yeah, it's really amazing.
One of the things, I've done this for a long time, so this reminds me of when airbag technology was migrating through the system, both front and side airbag systems. And I remember being deathly afraid of the consumer expectation test in that space as well. And we had a lot of cases where people would say, well, your design wasn't good enough. And about half the cases said, well, you should have had the other design. It was either a failure to equip, or you shouldn't have equipped it this way. But it was about half and half. And do you find that in these cases, if you're working on a consumer expectation test, how much do you have to spend time convincing people, go back in the time machine to what a vehicle was like in whenever this vehicle was introduced? Because with the proliferation of ADAS technologies that are hitting us, it's going to be hard for jurors to remember that. Has that been a challenge?
Yeah, definitely. And when you and definitely when we do focus groups, we often hear people don't seem to care much about feasibility. They want everything right now. They want, they want the safest possible vehicle right away. Um, but again, given more time to educate them at trial, the message does get home. We have it's not exactly the same issue, but we have a case for our electrical utility client locally, electrical contact case, and the issue is the design of their power pole. And we use actually airbags as an example. Like airbags are great, but not everything had airbags right away, even when they came out. And with airbags are also, a great cautionary tale because when they were first rolled out, what happened? They were too powerful. There were airbag induced injuries. So yeah, these are things given the time to educate that the jurors are, willing to consider. Although it is a difficult climate, and they do seem to. I mean, the first reaction I think is everybody's like, well, they should have just put it on there. They should just put everything right away, make it the safest possible vehicle from the beginning. But yeah, it just takes time and education, and they can see the light.
Yeah, I think the AAA survey that you presented, we should hold on to those because in the future, when everyone's gotten used to these technologies, we can say, no, remember when everyone was afraid,
Yeah,
right?
yeah. That's a great point and something we can use now. You know, because there does seem to be tension. When you talk to jurors in a products liability lawsuit, the sympathy factor is so high. It's like, yeah, just again, just do everything right away. But it's like, hey, folks, some of you are quite nervous actually about this technology, right? So it needs to be, it just kind of underscores it's got to be rolled out responsibly.
Yeah, there's factors. I know on some of my prior jobs, spent time developing those stories about what were the factors that caused companies to make those decisions. And those documents and those decision-making records were really successful later on in litigation when they come back and say, oh, everyone was doing it. You should have had it. When you talk about the supply base, the understanding of the technology, um, the different sensor systems that you're developing over time, the software development, all of it takes time.
Yeah.
So that's something that is a worthwhile effort for companies to document that decision making and how it's done. Because the questions, I think the challenges are going to come once the
Yeah.
technology becomes more ubiquitous.
Yeah, we got a question from Keith Trudgeon. If a manufacturer were to advertise a particular ADAS feature as providing a safety benefit, would that help to bolster the plaintiff case for consumer expectation? Yeah, I think it does. Or it's definitely relevant, to consumer expectation. I think the best evidence, and yeah, if you're holding out a feature as providing a safety benefit, and it's not in some of your vehicles, that's always going to be used against you. Um, but, I mean, the biggest issue in consumer expectations, I think, is what's the state of the technology, what's the state of the industry standards at the time of manufacture. But yeah, if you're holding out a technology as providing a safety benefit, that's always going to be relevant. And it's very interesting, I mean, ADAS features are advanced driver assistance features. I think initially they were viewed, or really the SAE framework was, and I know I've heard clients say this, they're convenience features, right? They're assistance features, they're convenience features, but more and more, I don't think people view them as convenience features. And I think the expectation is that you have to provide the safest possible vehicle more and more, and we just have
Yeah,
to show reasonableness.
I agree. And when you look at the NHTSA side, they're adding more and more of these features to their NCAP analysis. If you go to the NHTSA website, there's a whole series on all these different technologies. They're watching the development, and NHTSA is very quickly pushing in the safety direction on these things. And, to the question, not only in a product case, but in a NHTSA investigation or another government investigation I've handled, uh, they point to the advertising, they point to statements, they point to anything they can find and sort of say you misrepresented the vehicle that has caused uh, undue reliance on the technology, uh, and that's why people then got in an accident. It wasn't the fact that it was foggy or whatever else. It's your words induce this reliance, and I think that's a theory that continues to be pushed.
Yeah, yeah, and and when you have again, you got a green check or a red X next to your ADAS systems by the government. I mean, that's going to carry a lot of weight moving forward. Well, I think that is all we have for today. I appreciate everyone's time.
Yeah.
We will provide our deck to the participants, and CLE information will be forthcoming. Thanks, everyone.
Thank you.